Court of Michigan. All persons having business before this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the state of Michigan, and this honorable court.
Good afternoon. Welcome to the final argument of our first case call of the new term. Bank of America versus First American et al. You may proceed. Apparently you didn't get the same time memo that he got.
That's right. May it please the court, Richard Landau on behalf of Appellant Bank of America. And I'd like to reserve 5 minutes for rebuttal, but I understand I am responsible for monitoring my own time. This case presents this court with its first opportunity to address issues of liability and damages associated with residential mortgage fraud transactions. To date, the only opinions to consider mortgage fraud in a civil context are the two principal Court of Appeals decisions that are at issue here, the New Freedom decision as well as the instant appeal. And the New Freedom decision in large part dictated the results in the court below. But there's no question that mortgage fraud has been a public policy issue in this state and nationally over the past 15 years. The legislature, recognizing that the criminal justice system did not have its complete arsenal to deal with mortgage fraud, addressed this issue in 2012 when it passed a comprehensive mortgage fraud criminal statute. The facts before this court outline precisely the type of mortgage fraud scheme that falls within the purview of that criminal statute and implicate the same public policy issues here. As the Court of Appeals held, it is undisputed that plaintiff lost millions of dollars on the 4 mortgage loans at issue here, based on a fraudulent scheme involving straw borrowers, inflated incomes and appraisals, and other misrepresentations. Multiple people involved in these transactions have been criminally prosecuted. And it is undisputed that the bank sustained losses in excess of $7 million. This case is about the rights of parties to contract with one another to allocate the risks of loss associated with such fraudulent transactions. The bank has presented this court with 4 questions central to the determination of these rights. 3 of these questions address the interpretation of contracts intended to make a bank whole for the losses it sustains as a result of mortgage fraud. One such contract is the closing protection letters, or CPLs, the parties to which are First American, Title, and the bank. The second such contract are the closing instructions, which are the parties to which are the bank and its closing agents here, Patriot Title and Westminster. The bank is proposing first that the court find that the closing instructions are an enforceable contract between the bank and Westminster Title. Second, that the court find that there exists a genuine issue of material fact as to whether Westminster breached these closing instructions. Third, that the court find that there is a genuine issue of material fact as to First American's liability for the closing agent's fraud and dishonesty in closing the 4 loans at issue here, including the Westminster loans. And finally, the bank urges this court to reject New Freedom's application of Michigan's anti-deficiency statute to third-party participants in mortgage fraud through an improper application of the full credit bid rule. In undertaking this analysis, it's important to bear in mind the history and purpose of these contracts. As this record shows, as early as 1998 and once again in 2004, First American distributed to its agents an underwriting alert which warned of straw man schemes and the, quote, classic double escrow flip, close quote, precisely the schemes that defrauded the bank out of $7 million in these 4 transactions. This alert was cited by the Court of Appeals when it held that along with the bank's expert report, the bank had presented, quote, significant evidence from which to infer that the closing agents in this case knew or should have known that the transactions at issue were fraudulent. Lenders and title insurers recognized that there needed to be contractual mechanisms in place to allocate the risks of loss presented by such well-known mortgage fraud schemes. No bank would entrust its funds to these entities without these significant binding contractual assurances. Specifically, these contracts provide that in the event of loss, those sitting at the closing table as gatekeepers to the transaction the closing agents, will be financially responsible for their employees' misconduct, and that their insurer will indemnify the bank. Just as down payments serve as skin in the game for borrowers not to default on their mortgages, CPLs and closing instructions are intended to give title insurers and closing agents skin in the game, inducing them to be proactive in recognizing fraud, which is precisely why title insurers like First American issue alerts warning their agents about the dangers presented by fraud schemes to train them to recognize fraud and mitigate the risks they present to insurers and their agents. These contracts at issue here, CPLs and closing instructions, are comprehensive documents signed by sophisticated parties. They have been issued in literally millions of residential real estate transactions. These contracts have been subject to industry scrutiny, legal commentary, and a growing body of case law. CPLs are form documents. They are approved by the amicus American Land Title Association and issued by to their members in order to induce mortgage lenders to entrust billions of dollars to the care of these agents and to the insurer. CPLs are drafted so as to provide assurances to lenders that the substantial resources of the title insurers issuing the CPL will be available to reimburse them for losses arising from the fraud and dishonesty of their closing agents. Similarly, the closing instructions at issue here are the means by which the lender communicates to the closing agent what must occur as a condition precedent to the disbursement of the lender's funds and from the closing agent's escrow account. If a closing agent believes that a lender's instructions are unreasonable, they have an obvious means to avoid liability, refuse to sign the instructions, and decline the business. But Westminster signed the instructions and agreed to follow them. And like any contract, these instructions should be enforced according to their plain terms. Turning now to the first issue to be addressed by this court, the closing instructions between the bank and Westminster unquestionably constitute an enforceable contract. There's nothing unique or distinctive about residential loan closings or mortgage lending transactions that should cause this court to deviate from its well-accepted principles of contract construction. Yet, the Court of Appeals below violated one of this court's most important principles of contract interpretation when it held, quote, to the extent a separate contract existed between Westminster and plaintiff that required Westminster to follow plaintiff's closing instructions, the contract was modified and limited by the CPL, to which the parties manifested their assent by proceeding with the closing, close quote. This holding is directly contrary to this court's 2003 opinion in Quality Products and Concepts versus Noggle Precision. In that case, this court held that while the parties to a contract never cease to possess the freedom to modify a contract, any such modification must involve the parties' mutual assent. Furthermore, such modifications must be established through clear and convincing evidence of a written agreement, oral agreement, or affirmative conduct establishing mutual agreement to waive the terms of the original contract. The Court of Appeals violated these principles in a variety of ways. First and foremost, the closing instructions could not have been modified by the CPL because Westminster, the closing agent, was not a party to the CPL. While the Court of Appeals appears to be arguing that paragraph 1 of the CPLs, which does indeed reference closing instructions, modified the separate agreement with Westminster, that section of the CPL has nothing to do with Westminster. Rather, paragraph 1 sets forth the conditions under which First American can independently be held liable for a loss arising out of the violation of the closing instructions, irrespective of whether or not the bank chose to pursue the agent for the breach. Simply stated, that section of the CPL to which Westminster is not a party cannot be held to be any evidence whatsoever of a modification of the terms of the closing instructions, much less the requisite clear and convincing evidence of such modification, which is required by this court's precedents. It should be noted that even the amicus American Land Title Association effectively conceded this issue by choosing not to address it. Nor did First American choose to take a position on whether its agent was bound by the closing instructions. The proposition that closing instructions do not create contractual obligations on the part of closing agents is simply too far-fetched for even the title industry to accept. If this court is satisfied that the closing instructions are a contract, it must next address the second question, whether there was a genuine issue of material fact as to whether the closing instruction contract with Westminster were breached, whether the contracts were breached. There is ample evidence in this record to create a genuine issue of material fact as to whether Westminster violated the terms of the closing instruction. With regard to the Enid closing, the principal evidence of this breach was Westminster's failure to secure the required review and authorization of the final HUD-1 as provided by the closing instructions. The final HUD-1 is the HUD-1 that would have informed the bank where its funds were actually being directed. But the HUD-1 shared with the bank failed to do that. It failed to disclose the payoff of an undisclosed land contract in the amount of $2.4 million, which was the A side of the flip. If you consider the first part of the flip A and the second part of the flip B, we saw the B side of the flip. We never saw the A side. That would have disclosed it to us. The HUD-1 also failed to inform the bank that instead of bringing $1.9 million in cash to closing, the borrower in fact was bringing nothing to closing. Nor did it disclose substantial alterations to the dozens of debt payoffs set forth in the final HUD-1. Westminster was only authorized to close on this loan transaction, the one that was described in the final HUD-1, not the substantially changed transaction that they closed in its place. By failing to do so, Westminster dispersed these funds without authority in violation of the bank's instructions. As regards the Heron Ridge closing, the instruction that was most plainly violated there was that which limited third-party contributions to the lesser of 6% of the purchase price or the actual closing costs. Again, also requiring written authorization by the bank. The closing costs for this transaction for Heron Ridge were slightly in excess of $17,500. But while the HUD-1 represented to the bank that the borrower was making a $1.26 million earnest money deposit, and that the seller was paying over $550,000 out of his own funds to close the transaction, the source of the funds needed to close were actually unapproved third-party contributions, which were well in excess of $17,500. These included a $420,000 second mortgage closed by Westminster Title, which was not disclosed to the bank, a $108,000 check which came from one of the other closings at issue in this case, the Patriot closing of the Kirkway loan, and a $27,000 check that the borrower endorsed back.
Are you
Yes.
of the impression that we haven't read your brief and are unfamiliar with the...
I understand that. I will move on, Your Honor.
Good.
Thank you. Westminster was not authorized to disperse the bank's funds unless it received the bank's prior authorization for these concessions. That it failed to do so was a clear breach of the closing instructions. But rather than addressing these glaring problems with Westminster's conduct of these closings, the Court of Appeals instead directed its criticism to the bank's underwriting as an alternative cause of the losses from these closings. Yet neither the Court of Appeals nor defendants here have directed this court to any precedent whatsoever which relieves the title insurer or the closing agent of liability on the grounds that the bank engaged in negligent underwriting. The reason for this omission is simple. The law is uniformly against them. There's a substantial body of case law supporting the proposition that title insurers and their agents cannot be relieved of liability on the grounds of that the bank was negligent in its underwriting. The reasoning of these cases is straightforward as well. These are contracts between sophisticated parties. The bank's claims arise in contract, and the parties could have, had they chosen to, made underwriting a condition, an exception to liability in these contracts. The bank, in other words, First American or the closing agent could have made their liability contingent on the bank's agreement to follow an approved set of underwriting standards. But these contracts are silent as to the bank's underwriting standards, and contributory negligence is not a defense to a contract claim. Moreover, in the case of the CPLs, title insurers have agreed to waive the requirement of proximate causation. The CPLs require only that the bank's losses arise out of the agent's fraudulent conduct. Similarly, the closing instructions state that the agent shall be financially responsible for any loss resulting from its failure to follow the instructions. And as numerous cases have held, this standard of causation is easily met here, where against the guidance of a closing agent, against the guidance of its title insurer, disperses millions of dollars to fund loans to using straw borrowers, undisclosed payments to third parties with no legitimate right to the proceeds, and falsified down payments. The next issue for this court to consider is First American's liability under the CPLs issued to Westminster for the Enid and Heron Ridge loans. The Court of Appeals presented this court with another inexplicable lapse in logic in its discussion of First American's liability for these loans. With regard to the Patriot title closings on the Gulf Ridge and Kirkway properties, the Court of Appeals ruled that the bank's expert report, coupled with the underwriting alert I mentioned before, constituted significant evidence from which to infer that the closing agents in this case knew or should have known that the transactions at issue were fraudulent. Citing that evidence, the Court of Appeals properly concluded that the bank had presented sufficient evidence of liability under the CPL for the Patriot closings. For the Westminster closings on the Enid and Heron Ridge properties, however, the Court of Appeals found that the bank had failed to produce sufficient evidence to create an issue of fact as to whether Westminster knew of or participated in the underlying fraud. Yet for these closings, the Court of Appeals had before it the identical, quote, significant evidence that it had before it with regard to the Patriot closings, specifically the fraud alert and the bank's expert report. The bank's expert found the conduct of both Patriot and Westminster to breach paragraph 2 of the CPLs, and opined similarly that the closing agents for all these loans failed to follow their closing instructions. So what the Court of Appeals found to be significant evidence of fraudulent conduct and resulting liability under the CPLs and the Patriot closings did not even rise to the level of sufficient evidence in the case of the Westminster closings. The last issue presented for review by this court is whether the full credit bid rule is a correct issue of law and whether it applies to this case. The so-called full credit bid rule is not a common law rule developed over decades of reasoned precedent. It is purely statutory in origin, and the underlying statute was never intended to be applied so as to provide a safe harbor for defendants potentially liable for fraud. The statute in question, MCL 600.3280, is 324 words long. It took effect in 1933 at the height of the Great Depression. Nowhere in the statute does it say anything about providing a defense to third parties who are contractually liable for losses infected by mortgage fraud. The lender's bid at a foreclosure sale, according to the plain language of the statute, is a defense only to one enumerated class of individuals. Quote, the mortgagor, trustor, or other maker of any such obligation or any other person liable thereon, close quote. This is a Michigan statute passed by our legislature with the obvious intent of protecting borrowers from further collection efforts in the event a lender chooses to bid the credit owed by the borrower to satisfy the borrower's obligation on the underlying mortgage. Each state has its own statutory scheme for addressing the issue of protecting borrowers from excess deficiency judgments, which accounts for the differing applications of this rule in different jurisdictions. But the language of the Michigan statute is distinctive in that it provides an inducement to lenders to make a full credit bid. Because while the bank receives no funds from this transaction, all it is a paper transaction, In return, it receives clear title to the property, which allows the bank to expeditiously liquidate the property and realize actual funds from the sale. In other words, but the defendants in their amicus's reasoning, if a lender wants to preserve its action against a title insurer or closing agent, it needs to forego a full credit bid. In other words, the lender must preserve its right to pursue beleaguered borrowers or duped straws, potentially stripping them of their remaining assets and forcing them into bankruptcy. This interpretation makes no public policy sense. It benefits absolutely no one except the defendants contractually liable for losses resulting from admitted fraudulent conduct and concealment. It defies logic to assume that a legislature that has recently criminalized mortgage fraud would have intended another statute to be interpreted so as to create a safe harbor for perpetrators and their indemnitors in civil proceedings where the plain language of the statute says no such thing. Having found no support for their interpretation under the plain language of the statute, defendants have been forced to present alternative arguments that are easily rebutted. They argue, for example, that allowing lenders to pursue title insurers for closing agents for their losses after a full credit bid risks double recovery. Yet there is no dispute that the bank sustained actual losses of in excess of $7 million as a result of the frauds perpetrated here. As Professor Palomar has stated in her most recent supplement to her treatise, which we cited as supplemental authority, a treatise which was also cited by the New Freedom Court, defendants, and the amicus Alta, the amount of a lender's credit bid is not a proper measure of a lender's losses against non-borrower third parties. The bank made a paper bid at a foreclosure sale comprised of only the borrower's debt. The only funds that the bank received in return is what it was paid for the properties when they were sold after the foreclosure sale. And defendants have been credited with these proceeds in the bank's damage calculations. This is an accepted measure of damages in these cases, and there is no risk of double recovery. Defendants also argue that full credit bids reduce the, quote, leaven that might be yielded from the foreclosure sales from other potential bidders. Yet there's absolutely no evidence on this record which suggests that anyone other than the bank bid at the foreclosure sales.
When you say there's no chance of a double recovery, is that because the fact that your client made a full credit bid would still be relevant to damages vis-a-vis the third party?
No.
So why not?
Because there's no funds actually exchanged in the course of the foreclosure sale.
Well, but there's some value exchange if they take the property back and whatever the fair market value of the property. You're telling me that doesn't come into the damages calculation?
It does not, because there's significant case law authority in Michigan that the purpose of the foreclosure sale is not to assess fair market value of the property. The full credit bid rule and the bidding of the full amount of the debt serves the simple function of it is a statutory creation. We do it because it relieves the borrowers of a deficiency, and we don't have to go in and prove fair market value as a result. That's what the statute allows us to do, and in return, we get clear title to the property.
But as the result, your property then is whatever the fair market value is versus what you've paid creates the damage that you seek after third parties.
That's exactly right. We have the right then to liquidate the property and get actual funds through a sale to a willing borrower.
Is there anything else you have to say?
The only thing
Would you like to reserve some time?
I have reserved some time, so I will sit down. Thank you very much, Justice Young. And thank you very much.
Please the court. I'm John Monick. I represent Westminster. I'd like to recognize Stephanie Arndt. She's from my office. She did a lot of this writing, and we're always grateful for those things. I am going to leave the details to my brief. I'm going to make a couple of very succinct points and sit down. My perception of this particular thing is the devil lays in the details. Counsel's made a lot of statements with respect to the generalizations that he sees in his case and how bad Westminster was. His witnesses don't hold him up. You see, that's what the problem was in the Court of Appeals. The Court of Appeals, when they analyzed the statements that were made by Bank of America in their presentation, and they compared them with the testimony of the Bank of America witnesses, they found that one did not support the other. That's the general finding of the Court of Appeals. The Bank of America has always had a structural problem with this case, and that is it does not have a theory to pursue. Now, in the beginning, when the case was filed, they filed it with two essential theories. One was breach of contract, but the contract was never described. It was like a moving target. They couldn't decide how the closing protection letter played into a contract, if in fact it did, because the closing agent is not a party to that contract. That contract deals with the activities of the closing agent, but we do not sign it, we are not party to it. So they made this very vague assertion, which ultimately, by the time the case was over and by the time it comes to you, is that we had a contract to follow the closing instructions. But it's a very tenuous theory, and here's why. Each of the parties to this transaction has a role. The mortgage company had the role to loan the money, and in furtherance of its role, it had the interest to find out whether these people could afford to pay for this. These are large loans. These are exceptional people economically to be able to apply legitimately for these loans. These are substantial amounts of money. I've already gone through in my brief, and I will not belabor the fact that they had other reasons that they were doing this, and these were going fast, but I'll leave that for you to read later. But what happens is that they are not going to delegate this duty to a closing agent. That's not what they do. And they talk about alerts that happened in 2004. They started writing these stated income loans where they didn't check anything way after that date, and they did not notify us that they had changed their underwriting standards. We were not on any notice that something had changed. And in fact, they never published or changed their underwriting standards to conform with what they did with the stated income loans. They just did it. They just did it. As far as Westminster was concerned, when those loans came through, and remember, during the crush, we're closing 30 to 50 a day at this organization. They come in fast. We slap them into the machine, the closing statements come flying out, they go back to the bank rubber stamps them, and back they come, and boom, they're closed. Out the door they go. And the whole idea was that they were making money on this deal, and speed was an essential element. That is not my word. That is not my word. That is Quanah Clifton's word. That is Bank of America's closing representative's word. Speed was the deal. When we had the problem with the Enid Street closing, ladies and gentlemen, it was back in 3 hours. And it was a substantial problem. And they wanted to waive the survey requirement for a piece of property that had never been sold before, and that is never done. You can talk about having first position in a lien, but you always want to have a survey so that you know what you bought. So that is the reason why the loan was funded on 1/4 instead of on the date that it was closed, 12/30. We were waiting for the survey. Survey not completed. The closing agent's job is defined by the closing instructions, which they say constitute a contract. Well, they don't. The closing instructions deal with how you get this lien to be first. And when you're talking about these payments that are made, these mysterious payments, those payments aren't made, that person's interest goes before the banks, and that is not done. The payments that are made may be miscellaneous, they are probably on the HUD-1 before it goes in, but they are done for the purpose for what the closing instructions are for. Mr. Westminster, your job is to make sure Bank of America is number one in case this thing goes south. And in both loans in this particular case, they were. Now, the Court of Appeals said this, and I almost will close with this because this is, it says that Bank of America has to point to closing instructions and prove they were breached and show it would have made a difference. Because you see, the timing of this thing is such that the
What does
fraud
that
is
mean?
I'm sorry.
I thought in breach, what's make a difference?
Point to the closing instructions and prove, and show that it would have made a difference, in other words, as to whether the fraudulent loan would have been discovered. I did not fill in all of it. I apologize for that. The problem with all this is that the fraud was perpetrated by people who really wanted to commit a fraud. I mean, they planned it, they thought about it, they phonied up the down payment checks, and then the mortgage broker said to the bank that they had it in their escrow when they didn't. And then they got a phony appraisal so they could cover the amount that they didn't collect on the deposit check. Believe me, this was a
Please-
premeditated
Please
deal.
stand behind the lectern,
Yes, sorry.
behind the lectern.
Apologize. So, when the fraud is already finished, then they give it to Westminster. And they give it to Westminster with instructions to close it speedily. This is not anything where we're sitting and savoring this thing like a cup of coffee. This thing is going in and going out as fast as we can make it go. So,
What's the relationship that your client has with the bank if it's not a contractual relationship?
it is a situation in which we are the agent for our principal, First American, the insurance company.
Did they
We
have a
are
con-
an
do they have-
agent of
do they have a contract with the bank?
disclosed agent, an agent of a disclosed principal, there we go, sorry.
Well, yeah, but the principal has, your principal, First American, has a contract with Bank of America?
They do have a contract with them, but we also have a contract with our principal in which they say that we are, for the purposes of doing this work, their agent in fact. It's in the joint, there is a written contract between Westminster and First American. And what First American says is, you are my agent in fact for the purpose of writing these policies, providing the CPL, and doing all other related services in order to close it. And years ago, lawyers used to be hired to close mortgages, but now the title companies offered it as a service as part of a way to get some competitive edge, the way I looked at it, put attorneys out of business. But when I first started, attorneys were hired to close these things, so. But at any rate, in finishing, the Michigan Court of Appeals on page 16, it's an unpublished opinion, so that's the reason, that's the only page reference I had, concluded that BOA never would have proved that it had, I'm gonna start again, I apologize. BOA never proved that it would not have made the bad loans if Westminster had done everything it said it did not. In other words, there's no relationship between what Bank of America says Westminster did wrong and any possible resolution of the fraud that had already been committed by the time that Westminster got the file.
And that's based on what?
Pardon me?
That sounds like a factual determination to me. Who made that determination?
The Court of Appeals held that. That's from the Court of
On
Appeals
what-
decision.
On what
On what record?
factual,
Well-
what record basis did they have to make such a determination?
Well, it's the timing, and it's the role. The closing instructions only deal with getting first in line and title, and the fraud was committed completely before Westminster saw it, and the fact that there was nothing in the closing conditions that indicated that we were to check their underwriting, and the fact that,
No, let's leave underwriting aside. That's clearly not the role of those people downstream who are closing, right?
I apologize, I'm not a good hearer, and I'm not hearing you, Judge, I apologize.
I said, the bank's failure, in your view, to underwrite these things properly
That's right.
isn't the subject matter of the closing.
No. The subject matter of the closing is what Westminster said was designated to do in the CPL. It is to provide and arrange for the transfer of title and to make sure that Bank of America is number one on the lien. That's its job.
Okay? Is that what the contract says?
Pardon me?
Is that what the document said?
Yes, it does.
Okay.
It's the closing protection letter. And if you just give me a second, I think I can come up with it.
I think I have it.
Well, I'm not finding it.
I do. I'm just not seeing what you are referring to as, I mean, there are a lot more obligations than ensuring that the bank remains the prime.
You are correct. There are many more obligations under the CPL, but there's only one obligation that is at issue in this case because Bank of America has abandoned all the other ones. And that is,
I'm sorry, I don't.
yeah,
quite
fraud or
follow-
dishonesty of
just-
the
whoa.
closing agency.
Abandon, there are lots of things listed here,
Yes?
and you're saying they waived all of those.
We are down on fraud or dishonesty of the closing agent pertaining to the handling of funds or documents. That's all that's left.
Okay,
Yes.
and you're saying that your client had no obligation to avoid and not to detect fraud.
Their claim has to be that I committed fraud, not that I didn't detect fraud. You're starting to work into a negligence theory,
No, I'm just trying to understand.
breach of a duty.
I'm just trying to understand what these
Okay.
obligations are.
Right. Breach of a duty is a common law duty. They've abandoned all negligence and fraud and anything that has to do with comparative negligence claims because they don't want to try a comparative negligence claims for obvious reasons. So what they have said
So,
is
just
it's a
moment,
contract
just-
claim.
Just a minute.
Yeah.
What does the HUD 1 document compel your client to do?
Add correctly.
That's it?
Well, they plug the numbers into a computer and it comes out, and what is on the HUD one is the adjustment of the taxes, the purchase price, and all of those
It
financial
doesn't identify the
things.
parties and all that to the transaction?
I'm sorry.
It does not identify who the parties are to the sale?
It has their names. But remember, there's a purchase agreement that controls this entire situation. The HUD one is a derivative document. The purchase agreement is signed by both parties, evidencing the obligations, which will be officiated at Westminster's office to conclude the title transfer and protect the First Bank of America's lien.
Okay.
Yes, their names are on there. And on Enid Street, you will recall, the incorrect name was on the top, and it was returned to Bank of America. And Bank of America, instead of doing any underwriting, said, just do a quitclaim deed. They did nothing. It took them 3 hours to do it. I think I've run out of gas. I appreciate your attention to these issues. I would say to you that when I did argue this in front of the Court of Appeals, I said a similar thing, and I will say it to you. In this case, the joint index has many depositions, and there's a lot of pages of it and everything else. But the heart of this particular case is in the testimony of Bank of America's own witnesses, because when they were deposed, they didn't go to bat for Bank of America. They were very honest, and they were very forthright about what it was doing. And my interpretation was, and a little disgusted about the whole thing. There is no way that Westminster or anybody else knew that this activity was going on. And by virtue of the difference, that is, in the functions and the roles and the timing, Westminster can never be responsible for the underwriting of Bank of America. And I thank you all very much.
Thank you.
May it please the court, my name is Stephen Ribbiat, I represent First American Title. One thing before I begin, I want to correct an inadvertent statement of Mr. Monack in response to Justice Viviano's question about what is Westminster's relationship with the bank at the time of closing. So First American has a contract with policy issuing agents like Westminster. They're independent agents. In that agreement, it authorizes the agent to only issue title policies on behalf of transactions like this. And it specifically says you are not authorized to close transactions. When you're acting as a closing agent, you're not acting for First American Title. That's the reason we have CPLs. That's why these closing protection letters came about, because the banks were concerned, hey, you've got somebody who's closing this and they're not acting as your agent at closing, they're acting on our behalf, but we have no protection. So the closing protection letter provides indemnification and security for the bank that the person who's closing is somebody who's authorized by First American as a policy issuing agent, and you have the other obligations in the CPL. So in answer to your question, Justice Viviano, I think the best statement of what the relationship is between a closer under those circumstances and the bank, it would be one of, they're acting on behalf of the bank, but First American is obligated to indemnify the bank for a loss caused by that agent.
The title insurance company is trying to ensure that the parties who are supposed to be in this transaction are in fact, and the title, chain of title is as represented, correct?
That is correct. That is correct.
Doesn't this flipping stuff, these fraudulent transfers, doesn't that impede the ability of the title company at least to insure the transaction?
I'm not sure I follow the transaction is still insured.
But
And they're still
it's
covered.
predicated on some other parties than the ones that actually are engaged in the sham transaction.
Well, at the time of closing, Your Honor, the insurance is still in place we're still insuring the transaction. I guess the identity of the insureds may change at the time of closing. But yes, I mean, there's still insurance in place. No one from First American has alleged that there's not title insurance insuring the title of the property. We stand behind that.
Okay.
Just one other point, what I really want to speak to is the full credit bid rule. That's the issue that we briefed. But I don't want the court to think that by not fully briefing issues 1 and 2 requested by the court, that somehow by our silence, we're agreeing with Bank of America. That's not true. In our footnote in our brief, we pointed out that Westminster would be addressing those. Those were issues that directly pertain to Westminster. We agree with Westminster's position. We think the Court of Appeals decision was correct on that, but we didn't want to burden this court with duplicative arguments. So let me turn to the full credit bid rule. And there's an irony here, at least to me, that we're here because of fraudulent sham transactions. And in my view, what the bank is asking this court to do is adopt a rule of law or reverse the New Freedom Rule and itself bless what would in essence be a sham transaction by allowing the bank at foreclosure to bid what it's owed and then turn around the next day or sometime later and claim, no, that the property's not worth what we bid, it's worth something else. And I think the full credit bid
That may be an
rule.
interesting policy, but how do you derive it from the text of the statute?
Sure, well, I think what the statute is saying
The
is,
statute clearly does not contemplate those who, other than those who are responsible for the.
obligors of some sort.
The obligors,
Right, and I'm with you, Your Honor.
Well, then, if you agree with that, isn't that the end of this court's inquiry?
I don't think so, for a
So
couple,
we get to import public policy into otherwise unambiguous language of the statute?
no, Your Honor, I think there's 2 reasons why that's not the end of the line as it relates to an interested party to the transaction like First American Title. There's 2 reasons why.
Not an obligor.
It is not an obligor, although it is in effect an obligor based upon the position taken by the bank.
Only by virtue of the claim that they were engaged in a fraud.
No, First American, there's no claim against First American Title that it was engaged in fraud. The claim
Well, in
against,
what sense is it an obligor, though?
I'm sorry,
Which sense is it an obligor?
on the indemnity, on the contractual indemnity. That's the only claim against First American Title, that it is indemnified for its actual losses in connection with this loan transaction. And so in effect, all the
So
bank,
you're saying because it was indemnifying against certain actions of its agents, it is an obligor on the mortgage?
no, what I'm saying here, I am saying that what the bank has in effect done is substitute the borrower's obligation. The whole basis of the lawsuit is a loss on the loan.
Correct. But the statute doesn't deal with that. It deals with people who are actually obligors on the mortgage.
I understand that, but
All right, you're not an obligor, your client is not an obligor on the mortgage.
I completely agree. And it's not a guarantor either.
Okay, well, now I'm asking you why I get to extend the statutory process
Sure.
to persons who are not obligors.
Because it's the effect of that statutory process. It's, once the bank makes the full credit bid, there is no longer a debt. Okay, it has bid what it valued the property to be at whatever number it came up with.
And
It
that
couldn't,
becomes the fair market value of the house?
I'm sorry,
The fact that it makes a full credit bid establishes the market value?
well, here, the process is entirely controlled by the lender, right? It decides whether or not to foreclose. It decides what value to ascribe on the bid. It could have a foreclosure appraisal, those are done often, to determine what the right value is to bid.
But the statute is protecting people who are on the mortgage from the bank undercutting the fair market value and then having them be responsible for that. It has nothing to do with anybody else associated outside of the actual obligations on the mortgage. So I don't understand how I get to, as a judge,
Right.
say, well, it would be a good policy if the legislature had extended the protections given to the participants in the mortgage to people who are third parties to the mortgage. Why do I get to do that?
Well, I don't think you're doing it by.
But you've already said, the statute itself protects only obligors.
That's correct.
Okay. You're
And
not,
so-
your client is not an obligor, but
That
it
is
wants the protection of the statute.
It's not seeking protection of the statute, Your Honor.
Doesn't, what's this case?
New Freedom Mortgage.
Doesn't New Freedom do just that?
I don't think it does, Your Honor. I think that's the bank's interpretation of it. What New Freedom does is it says, by virtue of the statute, the debt has been satisfied. It's been statutorily satisfied. So
Yes.
then it says, as to a third party, where is the damage? You have bid their full credit, you have no damage.
Let's do this arithmetically.
Okay,
The fair market value of the house is $500,000. And through the fraud of, it was mortgaged for $1 million.
so you said 500,000 and $1 million, I just want,
Okay, double,
okay,
$1 million.
right.
So the default comes, the bank bids $500,000 to retain to regain the property. Okay?
Yep.
Your view is the bank has no loss under that circumstance. Is that what you're saying?
That is my position.
Oh, what happened to the other $500,000 then?
Well, Your Honor, by virtue of them bidding the full credit, which they didn't have to do, that is the effect of that transaction.
I don't understand why that is ineluctably so. It doesn't follow to me that if they actually try and gain something out of this transaction by bidding back a portion of what they've lost, they lose the entirety of their right to go against third parties who may have caused the $500,000 loss.
Well, again, I mean, I understand I understand your point of view.
If you understand it, then you should be able to explain it.
Well, that's how I view New Freedom Mortgage, and that's how I view how.
If that's so,
Well,
I'm asking what the logic of that case is based on.
Because
If there's actually a $500,000 loss to the bank by virtue of the shenanigans it was subjected to in extending $1 million loan.
And I think that the answer to that, Your Honor, is if the bank wanted to preserve the right to sue anybody for any deficiency or for any loss as a result of the transaction, it should not make a full credit bid. And it should take the time to understand whether or not there was fraud and bid the value of the property if that's what it wants to do. I think
Doesn't that hurt the property owner or the?
Not necessarily, Your Honor, because, see, there's two different, there's the innocent property owner, which is a transaction that has no fraud. Okay? It's just a straight-up transaction. And in those circumstances, I would think that the bank would not be seeking to have a deficiency judgment against somebody like that. And I would think that an arrangement, they need to know who their borrower is. And that's part of the problem here. There's this rush to get there's a rush to the process. Had they done any diligence whatsoever from the time of default to the time of foreclosure, they could have determined that there was at some point they determined there was a fraud. Why couldn't that have been determined before the foreclosure? And we are, to a large extent, Your Honor, innocent in this from First American standpoint, and we're also injured by it. Because by doing a full credit bid and releasing these borrowers, not all of whom are innocent, and in this case, they're called star purchasers, but they received $20,000 for these transactions. And in some cases, they're co-conspirators, too. So it's not as if it's this beleaguered, innocent borrower who's impacted by this. It's a co-conspirator who is. And by doing what they've done, they've impaired our subrogation rights. So now we have no recourse against these people that they have, by doing a full credit bid, have released the debt. And so I guess I want to leave on that point, unless subject to any other questions Your Honor may have. But there's an impact to innocent third parties or third parties, however you want to view us, as a result of this too. And it does have a consequence.
Do you agree with your co-defendant that closing instructions don't constitute contracts?
I don't believe they do. No, I believe they're instructions. They are what they are.
No, there's no Michigan law on that point, is that right?
None that I'm aware of, other than.
So you're free to disregard them. They're not, if they aren't contractual in nature, how do they bind your client?
Well, they do in this respect, and I think this is the point Mr. Monick was trying to make when you were discussing the closing protection letter. There are several obligations or protections provided by that, but one of which is that there is indemnity if the closing agent does not follow the closing instructions of the bank to the extent they relate to priority of title. So from First American standpoint, that's an obligation that our closing agent would have to, and that's the whole basis of title insurance and doing title searches and whatnot. The bank absolutely has to have priority of title at the end of the transaction. And if it does not, then there's a claim under the title insurance policy, or potentially a claim under the closing protection letter. I hope I answered your question.
I think you did. There's some out-of-state cases that suggest that closing instructions are contracts. Any reason why you think those don't apply?
Well, the cases from Florida and the others that have been submitted.
California.
In California. Your Honor, all I can say, I've always understood them to be simply an instruction, not a contract. And I don't know.
So like what you tell your children, don't do that? Not binding?
It's
I
binding on
prefer you do this.
it's binding on my kids, Your Honor.
Oh, is it? Well, you have a different household than I.
At least until they're 18 and get out of my house, right?
Yeah, okay.
Anyway, I appreciate the court's time.
Thank you.
Thank you, Justice.
Thank you.
Can't spank the bank.
How about that? Does the full faith foreclosure pledge, or whatever that's called, impair the subrogation rights of people?
I wanted to address that, Justice Young, because it does have some significant public policy implications for this court. Understand.
Let me just ask the factual or legal question.
Does it impair the?
Does a full credit bid, when accomplished, extinguish the subrogation rights, the people who might be liable to your client for indemnity?
It extinguishes our right to pursue the borrower.
Does it extinguish their right to?
I don't believe it does.
Why?
No. Because I believe that under those circumstances, they can argue that they can argue under a theory of tort liability at that point, that they essentially conspired to create a loss for First American title. But there's another issue I'd like to address here, and that is, bear in mind that.
Let me just, before we.
Sure.
Isn't it generic sort of principles of law that that it would extinguish their subrogation right?
Our rights vis-à-vis the borrower are extinguished. However, if they want to make an argument that somehow they were joint tortfeasors in a fraudulent conspiracy.
Well, does the statute extinguish the borrower's obligations to any other party?
No. No, it extinguishes our obligation. But I want to make one point with regard to subrogation. Understand that what counsel is arguing is that if they are arguing that we are impairing their subrogation rights, that means that in every transaction where there is a potential for fraud, they will require us to seek deficiency judgments in those cases. Right? That vis-a-vis us, we have a contract with them that says we will not impair their subrogation rights. All right? That means that we, therefore, have an obligation to pursue the borrower for them. What he's saying that in these particular loans, well, the borrowers were dirty. Well, that may be true, but understand that if we ever, sometimes the borrowers aren't, and the public policy, they want lenders now, under their interpretation of the law, to always go after borrowers for deficiencies, because if we do not do that in every case, they will not accept our claims. Just as they require us to foreclose properties in order for us to have a loss, which they do. They're going to say at this point, from that point forward, if that becomes the rule here, first of all, understand that they've never raised impairment of subrogation in any of the proceedings below, and our position is that it's waived. But let's take them at their word and say that will be their practice. If now this court institutes a rule that says that the full credit bid, in order for us to avoid the draconian effects of the full credit bid rule, we're going to have to make market value bids and pursue deficiency judgments against all borrowers, just in case, and there's material before you. It sometimes takes years to uncover mortgage fraud.
What was the world like before New Freedom with respect to this
The world
question?
was, we were able to collect under closing. In fact, back when I started this business, it was not unusual for us to send CPL claims to entities like First American Title, and they would pay them by return mail. They don't do that anymore because of New Freedom. It's basically they now have an argument that they are not liable on this debt, and we're on the horns of a dilemma. If we don't foreclose, or if we foreclose for fair market value, we're going to have to pursue we're going to have to pursue borrowers. It's going to take years to establish fair market value in judicial proceedings, and while that's happening, those properties in Detroit and Lansing are sitting on the market deteriorating. The full credit bid allows us to make that bid in a foreclosure by advertisement, take the property, sell it, and put it back into the marketplace and allow it to begin being a worthwhile property once again. And if you have any other questions,
Thank you very much.
thank you very much.
Case is submitted. We're concluded.